Anger. Welcome to our next in our series of healthcare compliance webinars. I'm joined today by my partner, Alex Grande, who will talk about some of the employment issues. We're thinking about, okay, what are some of the things that you as healthcare entities you need to be concerned about in the employment context? To that end, this presentation, we're going to cover a bunch of different topics. And it's more of a we're not going to get into in depth on really any of these. We won't have time to, but we just wanted to make sure that you as healthcare employers, that you're aware of some of the issues that may be out there that may affect what you're doing. This is just going to be an overview of some of the key considerations, focusing primarily on federal laws, but remember that there may also be state laws that apply. So when it comes time to applying or using any of these suggestions or comments in your particular practice or your facility, then make sure that you're aware of your particular state law requirements as well as the requirements of applicable federal laws. You should have received a copy of the PowerPoint slides. If you did not, feel free to contact Lisa and she can make sure that she gets those to you. If you have questions as we go through the program, we won't take questions during the program because we record these and make them available for future use. But you can go ahead and submit those questions to me either using the chat feature, or you can go ahead and email me and we'll do our best to respond offline. Because we won't be able to go through all of these items in detail, I have provided you with several different articles I've written over the years dealing with different employment issues in the healthcare context, particularly those dealing with the Stark and the anti-kickback statutes. You can access those on our website or through the links that are provided there in those PowerPoints. All right, with that preliminary stuff out of the way, let's talk about some of the employment issues. The first is, are you working with this particular person as an employee or as an independent contractor? Perhaps more so in the healthcare context than I see in other situations. A lot of times, especially unsophisticated employers may decide that hey, we don't want to pay taxes or withhold taxes on this guy, so we're just going to hire him as an independent contractor. Well, that may or may not be appropriate. There are different laws and different standards that apply to employees versus independent contractors. There are certainly benefits, but there are risks associated with misclassification for these persons. The general test between an employee versus an independent contractor is the right of control, at least under the IRS and under most state laws. If it's an employee, of course, then the employer's got to withhold taxes. The employer can be vicariously liable for what that employee does within the scope of when they're acting within the scope of their employment. Different employment laws are going to apply, like the discrimination laws, wage and hour laws, and the like, that I think Alex will talk about a little bit later. And if you're an employee situation, it's easier to comply with some of the federal regulations like Stark and the anti-kickback statute. On the other hand, if you're an independent contractor, then there typically is no right of control, and consequently, you're not vicariously liable for what the person who hires them. The principal is not vicariously liable for what the independent contractor does. But you got to make sure that you can satisfy that test to establish that this person really is an independent contractor and not just an employee that you've characterized as an independent contractor. Of course, if it's an independent contractor, the employer does not withhold the taxes the contractor must pay. But if you've done that misclassification improperly or misclassified the person, then it's possible that the IRS could come in there and recover any taxes from the putative employer that were not withheld. A few years ago, the IRS was looking at healthcare contracts more carefully than I think that they have been recently. So I'm not as concerned about the IRS coming in there to audit, although they may. I'm more concerned about situations where you may have a person who is characterized as an independent contractor, and then they come in later and say, well, I was really an employee, and therefore you should have paid me all these or made available all these employee benefits. So you've got to not only be worried about the IRS, but the employee, or maybe a third party alleging that there's an employment relationship. When it comes to Stark and the anti-kickback statute, the requirements for complying with those statutes are significantly stricter for independent contractors than employees. As we'll talk about in a few minutes, employees, you have a lot of leeway, but not so with independent contractors. The bottom line is, therefore, you need to make sure that before you characterize a person as an independent contractor, they truly are an independent contractor. You can go to the IRS's webpage, and at least for IRS purposes, they've got some guidance concerning making that determination on whether or not the person's an independent contractor, an employee. You can work through the guidance that the IRS has provided on that. The IRS used to have a 20-factor test that was helpful. They've kind of gone away from that now and just really focus on control, on concerns dealing with control over issues like behavioral issues, financial issues, or the type of relationships. All right, let's talk next about the corporate practice of medicine. Some states take the position that corporations or certain other entities cannot employ physicians, dentists, or certain other licensed healthcare providers. The theory is that, hey, the Medical Practices Act, it allows individuals to practice medicine, but it doesn't allow corporations to practice medicine. And we don't want corporations making decisions concerning healthcare. And therefore, in those states that recognize the corporate practice of medicine, they generally prohibit corporations from employing physicians or other entities in providing health care. Now, there are some common exceptions that most states, even if they have a corporate practice of medicine doctrine, that they will allow hospitals or similar facilities to employ physicians or other licensed healthcare providers. They'll usually allow managed care companies, HMOs, and the like to do it. They also have, usually under their corporation statutes, they allow for professional corporations or PLLCs that are owned by these licensed professionals, and in those situations, they can go ahead and employ or provide services through the corporation. In those states with corporate practice of medicine, it really varies, right? There's lots of different states, and the corporate practice of medicine, the degree of strictness for corporate practice of medicine in a particular state may be different from what exists in another state. So you kind of have to know what your particular state is. There are, depending on the state, there are certain ways to get around corporate practice of medicine issues. A lot of times you will, instead of hiring the provider, you will go ahead and just enter into an independent contractor arrangement with them, or maybe set up a management services organization or certain other ways. The bottom line here is make sure that you are aware of the law in your particular state, including any licensing board requirements and the like that may limit your ability to just simply employ a particular type of healthcare provider. Also, be careful to the extent that you're engaged in telehealth, because in your particular state, the corporate practice of medicine may not apply. But if you reach out and provide services to a patient in another state, that other state may have corporate practice of medicine issues, and therefore you may violate the law in that other state where that patient is located. There are some resources online that will give you kind of a 50-state summary. Permit Health publishes one, but there are others online. So just make sure you're aware of the corporate practice issues. All right, when you're going to hire a healthcare provider or other people, you need to make sure that you do appropriate background checks and credentialing to ensure that they are not only qualified to do what you're asking them to do, but they're also licensed. There are some specific requirements that you have. First of all, you've got to, if you're going to participate in Medicare or Medicaid, you need to check the list of excluded individuals and entities. I'm going to come back to that one in just a minute. If you're a hospital, then you also need to check the National Practitioners Data Bank to see if there are any reports on physicians or certain other healthcare providers that are out there. In each state may have their own additional requirements concerning background checks that you need to conduct for certain types of healthcare providers. Usually those depend upon that employees' access to, children or others. There may be specific requirements. Make sure you're aware of that. As a general rule, though, you need to make sure that you are engaging in appropriate credentialing, privileging, and or checking the licensure of those employees who are going to be providing services. Not only your employees, but your contractors. For employees, if you fail to get people in there who are qualified, then obviously you can be vicariously liable for what that person does. But also, you can also be subject to liability under the separate tort for negligent hire in your credentialing. In addition, even if you're not worried about the patient suing you, you're going to have a hard time getting paid by payers if you are providing services through somebody who is not credentialed or licensed. Licensure is an issue that comes up fairly frequently. You may hire a physician or another provider in there to render services, suddenly you discover that that person either wasn't licensed or their license lapsed, and you've been billing for those services as if they were licensed. Well, that can create a false claim situation under federal law or perhaps state law that may require you to do repayments back to the federal government in those situations. The bottom line here is that it's really important for you to make sure that you stay atop of the credentialing, making sure that your providers have qualifications necessary in order to provide the care, that they have the licensure that's required, not only when you hire them, but you need to keep on track of that, on top of that throughout the life of that employment relationship to ensure that you can properly render the services and bill for those services. To the extent that you are engaging in that credentialing or privileging, just a side note there, you'll want to make sure that you're familiar with your state law's peer review privileges and the protections under the Healthcare Quality Improvement Act so that you can get the immunities that are provided under state peer review protections or the Healthcare Quality Improvement Act for any adverse action you may take against that provider based on your credentialing decisions. All right, remember I mentioned that exclusion statute that you need to make sure that you're complying with the LEIE, the list of excluded individuals and entities. That's because of the federal exclusion statute. This statute says that an excluded person cannot order or prescribe, a person who's been excluded from participating in Medicare or Medicaid cannot order or prescribe items or services payable by federal healthcare programs. And not only that, you cannot, if you have an employee or other person who provides those services, you cannot submit a claim, knowingly submit a claim for an item that's ordered or furnished by an excluded person. Not only that, excluded owners cannot retain an ownership interest in an entity that participates in Medicare, and you cannot hire or knowingly hire or contract with an excluded entity to provide items that are payable by federal healthcare programs. If you're blackballed from the Medicare or Medicaid program, then that not only prevents you from ordering items or services payable by Medicare or Medicaid, but it also prevents your employer from hiring you. If you're an employer, you need to check that list of excluded individuals and entities before hiring individuals and periodically thereafter in order to determine whether or not they've been excluded. Because if they have been excluded, you can't use any money from Medicare or Medicaid. You can't submit services that were rendered by them, bills for payment for services rendered by them, and you can't use any money you get from Medicare or Medicaid to pay these excluded individuals. If you find out that you have hired an excluded individual and you're participating in Medicare or Medicaid, then you may likely do have a repayment obligation back to the federal government. And the government has a kind of a formula, a process for calculating the amount that you're going to have to pay for hiring this excluded individual. Importantly, this is not just for healthcare providers, it's not just physicians, but it's anybody in your organization, that any employee, potentially contractors that you hire or engage in, if they're excluded, then you may bump up against this exclusion statute. Now, it only applies if you know or should have known that they were excluded. Well, how do you know or should have known? Well, again, the government publishes that list of excluded individuals and entities. So if you do not check on that on a regular basis, then you may be deemed to have knowledge that that person has been excluded, and you could have that repayment obligation back to the federal government. For more information about that exclusion statute, you can go to the Office of Inspector General's website. They've got a bunch of FAQs concerning the exclusion statute. And they've also posted an advisory bulletin talking about the effect of program exclusion. The bottom line here is make sure that you're regularly checking your list of excluded individuals and entities against your employee database and potentially contractor database, not only when you hire them, but periodically thereafter to make sure that you're not hiring or contracting with these excluded individuals. All right, let's talk next about the fraud and abuse laws that may apply. The first is the federal anti-kickback statute. If you're engaging in Medicare or Medicaid or other government programs, you need to be concerned about the anti-kickback statute, which prohibits you from knowingly and willfully offering, paying, soliciting, or receiving remuneration to induce referrals for items or services payable by a government healthcare program or a government program unless the transaction is structured to fit within a regulatory safe harbor. It's very broad. It's paying, offering benefits, offering any kind of remuneration, anything of value to somebody in order to get referrals. a violation of the anti-kickback statute, it's a felony. In addition, you can, in addition to going to jail and paying criminal fines, you can get hit up with civil penalties. You also, it would violate the False Claims Act, so you'd have repayment obligations. It is extremely broad and applies to any type of remunerative relationship with a referral source, but fortunately, there is a safe harbor that applies to employees. So under the anti-kickback statute, employee safe harbor, remuneration that would otherwise trigger the anti-kickback statute does not include any amount paid by an employer to an employee who has a bona fide employment relationship with the employer or employment in the furnishing of any item or service for which payment may be made in whole or in part under the Medicare, Medicaid, or other federal health care programs. It's very broad. The bottom line is, if you've got a bona fide employment relationship and you're paying somebody through that employment relationship, you don't generally need to worry about the anti-kickback statute. There's some older cases that talked about, well, what is a bona fide employment relationship, and are you really paying them to provide services for which the federal program is providing, or are you paying them for referrals or something else? I think that those have pretty much been discounted. I think I've given you an article that talks about, that I drafted, talking about the anti-kickback statute and requiring referrals for employees, if you have further questions on that. But the bottom line appears to be, at least currently, that if you are a bona fide employee, that you generally don't need to worry about the anti-kickback statute. That is not so with the Eliminating Kickbacks and Recovery Act. This is a separate statute under known as ECRA. Under ECRA, it's like the anti-kickback statute, but in some ways it's broader and narrower at the same time. Like the anti-kickback statute, it prohibits soliciting, receiving, paying, or offering any remuneration in return for referring a patient, but it only applies to patients for laboratories, recovery homes, or clinical treatment facilities, unless the arrangement fits within a regulatory safe harbor. What happens if you violate this? Well, again, it's a felony. You can pay a $200,000 criminal fine or up to 10 years in prison. Now, the anti-kickback statute only applies to referrals for items or services payable by federal healthcare programs, but the ECRA applies to any type of payer, not only federal programs, but also private payers. The anti-kickback statute does have that safe harbors for employees. ECRA also has an employee safe harbor, but it's not as broad as the anti-kickback statute. Under ECRA, it does not apply if there's a payment made by an employer to an employee or independent contractor or employment if the employee's payment is not determined by or does not vary by the number of individuals referred to a particular laboratory, the number of tests or procedures performed, or the amount billed or received from in whole or in part from the healthcare benefit program. So bottom line is, under the anti-kickback statute, you could probably pay employees based on their referrals. Under the ECRA, you cannot pay employees based on their referrals for labs or these treatment facilities. So if you are operating a lab or a recovery treatment home in your facility, even if it's not related to substance use disorders, then you got to be concerned about ECRA. Make sure that your compensation program for your employees is structured to fit within this safe harbor. Generally, you cannot pay them based on the volume of value of their referrals. That's just a sub note because a lot of people don't remember ECRA. If you're operating a lab, though, make sure you're aware of ECRA. All right, that brings us to the Ethics in Patient Referrals Act, or the Stark Law. Unlike ECRA and the anti-kickback statute, which applies to any types of healthcare provider or really entity, any other entity that's engaged in programs, federal programs, the Ethics in Patient Referrals Act only applies to referrals by physicians. So if you're doing any kind of an employment deal, contractor deal with a physician, then you got to be concerned about the Stark Law. Stark says that if a physician or a family member has a financial relationship with an entity, which can be an employment relationship, then that physician may not refer patients to that entity to the employer for designated health services that are payable by Medicare or Medicaid. And if they do make improper referrals, that entity may not bill Medicare or Medicaid for those referrals, for those services provided, unless the arrangement is structured to fit within a regulatory safe harbor. If you violate that, then you can have all sorts of civil penalties, also repayment obligations back to the federal government. It would be a violation of the False Claims Act, so there can be multiples on the repayment obligation. Now, just like the anti-kickback statute, there are safe harbors under the Stark law, particularly, there's the employee safe harbor. But the employee safe harbor under Stark is not as broad as that under the anti-kickback statute. In order to fit within the employment safe harbor, you're going to want to make sure that your employment contracts for physicians, or if you're employing a member of the physician's family, you've got to make sure their employment contract satisfies the following. Stark doesn't apply if the amount is paid by an employer to a physician or immediate family member who has a bona fide employment relationship if the following conditions are satisfied. First, the employment has to be for identifiable purposes or services. Second, the amount of the remuneration under the employment has to be consistent with fair market value, and it cannot be determined in a manner that takes into account the volume or value of referrals. That's usually where you get in trouble. You need to make sure that the compensation you're paying your physicians or their family members represents fair market value and is not based on the volume or value of referrals. A couple of points there. In the 2021 commentary that came out accompanying the Stark Law revisions, the government confirmed that fair market value, it's a range, right? And there is no standard test or safe harbor like MGMA numbers or anything like that. You have to look at the overall circumstances of the particular employment relationship. It may be a situation where you may have to pay an employee more money to work in a particular location than in another location. So for that particular, in that particular situation, fair market value may be higher. Other situations, fair market value may be lower because of demand or whatever it might be. So you have to really look at the particular situation. There is no safe harbor. And you need to make sure that that compensation does not vary with the volume of value of referrals for designated health services. Now, unlike the contractor safe harbor, the employment safe harbor under Stark only prohibits you from conditioning or varying the compensation based on the value of referrals for certain designated health services. You could, under Stark, compensate those physicians based on the volume of value referrals for services that are not designated health services under Stark, but be careful, okay? There are some other requirements. The remuneration has to be commercially reasonable. You can't just do this deal even though you don't really need it, just as a way to float money to the physician to get their referrals. It has to be, the overall arrangement has to be commercially reasonable even if there were no referrals. This does not apply to services that the physician personally performs. If the physician's personally performing the service, it's not a referral, and you can always pay the physician based on the service the physician personally performs, but you can't pay them based on their referrals for services that are performed or ordered by others. Now, importantly, under the Stark Employee Safe Harbor, again, it's pretty broad. Under the safe harbor itself, you generally don't even have to have it in writing. The compensation formula does not have to be set prospectively. It can be changed at any time, including retroactively, subject to one caveat. And that is, if you're going to require the employee to make referrals to your particular organization, like if you're an ED doc, this physician's an employee, that he has to refer patients to your hospital in order to get for any labs or any additional services, then you would need to make sure that Stark would allow you to go ahead and require those directed referrals if you satisfy certain conditions that I'll talk about in just a minute. But if you are going to require that, then the employee safe harbor says that your employment contract in those situations has to be written and the compensation has to be determined prospectively. There is a new safe harbor that also allows you to pay a physician, including an employed physician, less than $5,000 per year, subject to inflation, without having to satisfy all the requirements of the employment safe harbor, but the requirements are generally similar. The compensation can't be determined in a manner that takes into account the volume of value of referrals. The compensation cannot exceed fair market value, and the arrangement still has to be commercially reasonable. There's a separate Stark safe harbor that applies to group practices, that if you are a group practice, you can compensate your group practice members. You just have to make sure that you're not compensating them in a way that is directly affected by the volume of value of their referrals. But the group practice safe harbors have some specific sub-safe harbors that the compensation is deemed not to take into account the volume of value of referrals if you satisfy certain requirements. There's requirements applicable to bonus programs. There's also requirements applicable to share of profits. So if you're a group practice, when you set up your compensation structure, generally you're going to want to make sure that you comply with these group practice requirements for setting up that compensation. Among other articles, one of those articles I did provide to you was kind of a summary of these rules, explaining why you need to be careful of eat what you kill compensation arrangements in group practices. There are other safe harbors that might apply in the employment context, including those for personal services, fair market value, recruitment. If you need to pay an employee more than fair market value, then you could use the recruitment safe harbor if you're a hospital, but you have to satisfy additional requirements. But when you're talking about employment relationships, really it's the employee safe harbor that's the most important when it comes to Stark. All right, I mentioned the directed referral requirement. Stark does allow an employer to require its employees to refer patients or designated health services to that particular employer. So if you're a physician group, you could require that your employees refer labs to your internal lab, or they can refer it to your imaging center. You can do that under Stark, so long as you satisfy certain requirements. Those requirements are that referral requirement has to be set out in writing and signed by the parties. The compensation has to be set prospectively for the duration of the agreement. The compensation has to satisfy other safe harbor requirements, such as fair market value, and it can't be based on the volume of referrals. The referrals have to relate solely to the physician services under the contract and must be necessary to effectuate the legitimate purposes of the arrangement. And that referral requirement cannot apply if, you have to have an exception that would apply if the patient prefers to go to a different provider, or the insurer determines the provider, or the physician determines it's not in the patient's best interest to send them to this. So if you're a healthcare employer, you may want, and you provide a lot of ancillary services or provide other specialty services, you may want to look at your contracts and see if you want to include this directed referral requirement in there to keep those services in network. And at least under Stark, you should be okay. Now, you still have to be concerned about the anti-kickback statute and any state law requirements. So you'd want to run those issues through those particular statutes to make sure you're okay. But generally, if you're complying with the Stark rules, you're likely going to be okay. All right. There is another statute out there, the Civil Monetary Penalties Law, which in addition to containing the exclusion statute, also states that a hospital or critical access hospital cannot knowingly make a payment directly or indirectly to a physician as an inducement to reduce or limit the medically necessary services that are provided by Medicare or Medicaid. And the purposes of this is when the government switched to the prospective payment system, so that the government theoretically pays X dollars for this diagnosis code, they were concerned about situations where the hospitals would go to physicians and say, hey, if you help us reduce costs, we will share some of those cost savings with you. The government was concerned about that, and therefore they passed this law that basically prohibits offering those inducements to physicians or other providers to reduce medically necessary services. If you violate that, then that could be, you can get subject to additional penalties. You can be excluded from Medicare or Medicaid. So you generally have to be aware of those gain sharing arrangements. Now, note that that would not apply to Medicare shared savings programs, the MSSP program. The government carved out those, but other than that, be careful of those types of gain sharing arrangements. If you're a 501c3 entity, you also have to be worried about overpaying physicians or other insiders, because that could result in private inurement and result in adverse tax consequences or penalties to you. In addition to those federal laws, you've also got to be concerned about some common state laws that may apply in the employment context, including compensation arrangements, including state anti-kickback statutes, state mini Stark or self-referral statutes, ownership limitations, fee splitting statutes, and the like. All right. Let's talk briefly. If you're going to hire somebody, bring them in as an employee, make sure that they are practicing within the scope of practice. Remember, your Medical Practices Act says that, hey, only licensed providers can engage in the practice of medicine. So be careful about having your employees delegate to people who aren't licensed to practice or engaging in such actions without supervision. So make sure that you're aware of what those requirements are in your particular state. Not only in your state, but if you're going to provide services in another state through telehealth or the like, make sure you're aware of the rules that may apply over there. For example, your particular state may require a practice collaboration agreement with a physician assistant. If that's the case, you need to make sure that's in place, but the requirements for that other state may differ. So make sure that you're aware of those issues. Briefly talking about confidentiality. If you are billing third parties engaged in insurance or the like, then chances are you're going to be covered by HIPAA. Covered entities and business associates are vicariously liable for members of their workforce, including employees. Now, for your employees, you do not need to have a business associate agreement because they're not business associates, they're your members of your workforce. And there's an exception under HIPAA that says you don't have to have a business associate agreement for members of your workforce. But under HIPAA, you are required to train your workforce members and document the training. You've got to implement policies and safeguards, including security rule policies, especially if they're working from home and the like. You got to make sure that any of those systems that you set up are going to comply with the HIPAA security rule requirements. You've got to also comply with the minimum necessary standards, which, among other things, requires you to implement policies to identify employees by role-based status to determine what records they should have access to and those that they do not. So you should have those minimum necessary standards that apply that limit employee access to just those records or that information that they need in order to provide their services. You've got to, if there are violations under HIPAA, you've got to sanction your employees and document your sanctions. If you fail to do so, then you could be liable for HIPAA violations yourself. When it comes to employees, really beware of the use of their personal devices. If they're capturing any protected health information on their personal devices, including texts, emails, photos, or anything like that, HIPAA is still going to apply, and you need to make sure that personal device satisfies the HIPAA security standards as well as the privacy standards. Beware of texting or emailing via unsecure means. That can violate the HIPAA security rule unless you get patient consent. Beware of the employee's presence on social media where they may inadvertently or intentionally disclose protected health information. Those are just a few of the areas of HIPAA confidentiality you especially need to be aware of when it comes to employees. In addition to HIPAA, a growing number of states have their own privacy laws, so make sure that you're complying with your own privacy requirements in those particular states. Even though HIPAA does not require you to have a business associate agreement with your employees or members of your workforce, you should make sure that you've got confidentiality agreements with your employees, either in their employment contracts or handbooks or something that they sign that requires them to maintain confidentiality. That will be a helpful safeguard to comply with HIPAA, but it can also be really helpful to ensure that they don't take your confidential information or use it improperly after they leave your employment. Just a word about mandatory reporting obligations. If you're in the healthcare context, you may have an affirmative obligation to report adverse employment action that you may take against physician or other employees. For example, if you take adverse action against a physician and it results in the loss of their privileges, then you may have an obligation to make a report to the National Practitioners Data Bank if you're a hospital or otherwise participating, a group participating in the NPDB. Now, typically that only applies if you're taking adverse action against the physician that results in adverse action against his privileges to perform those services, and that adverse action is related to the physician's professional conduct or competence that could adversely affect patient care. Just terminating their employment probably isn't enough, but if you terminate it based on professional conduct or competence and they've gone through a hearing process under the bylaws or otherwise, then it could be reportable to the NPDB. Separate apart from the NPDB, there may also be state licensing board requirements. Some will require you to report adverse employment actions. So make sure you're aware of those types of state laws that may also apply. You may want to check your laws, contracts, and bylaws or policies to ensure that they're compliant with the laws when it comes to the mandatory reporting. I got this question recently, so thought I'd throw in a slide on this. What do you do when a physician leaves? Is that engaging in patient abandonment? Are you liable for patient abandonment if you have a physician or other provider who leaves? The general rule is that once you establish a patient relationship, that provider has to continue to provide care for that patient. If they don't, and the patient suffers harm, then there could be patient abandonment. To avoid patient abandonment, generally you have to give notice to the patient before terminating the relationship, give the patient time to transfer care, and provide necessary care in the meantime. Well, what happens if that provider just doesn't give advance notice and just decides to leave? Does that mean that you as the employer are subject to patient abandonment? Well, probably not. If you're are willing and able to continue to provide the patient care to the patient, because the patient can still receive their care. It may be an issue if that provider terminates or leaves and leaves you in the lurch, so you can't provide care for the patients, and you may be able to use that against the provider if they are trying to leave without providing adequate notice and an opportunity to leave. A good thing to do is to address those types of issues in your employment contracts or your employee handbooks, dealing with things like the required notice in advance of termination. Also, maybe work with the provider to come up with an appropriate notice to the patients if you decide that you want to send that out. Just a quick word on OSHA and workplace safety. There are some specific standards for healthcare providers, as you all know, for bloodborne pathogens and the like. The one that I wanted to mention is workplace violence. That's a growing issue that's been a real concern, particularly for our hospital clients and maybe some other healthcare providers, mental health, behavioral health care centers and things like that. The government a few years ago was looking at proposing workplace violence standards, OSHA standards, specific standards for healthcare entities. To my knowledge, they have not issued those, although the word we're getting is they may be coming down the pipe under the new Trump administration. I'm not sure if that's going to occur anytime soon or not, but just be aware of that. Until then, however, you're still under the general duty clause under the OSHA, so you are required to take appropriate steps to minimize workplace violence. A quick word about conscience laws. There are various federal and state conscience laws that may allow employees to decline to provide certain types of health care if it's against their moral, religious, or ethical standards. The laws are differ. There are federal laws that apply to things like abortions. State laws may apply to abortions or contraceptives, advance directives, or end-of-life decisions. They usually apply to any actions that would be against religious beliefs or moral or ethical concerns. Most of the state statutes will have like a process that standards that have to be satisfied if the physician is going to assert or the provider is going to assert those types of objections. And they also usually have some kind of a transfer requirement to make sure that the patient's care is transferred appropriately. You as an employer need to be sensitive to those rights so that you're not violating the employee's rights and forcing them to do something that they shouldn't in violation of the applicable law. At the same time, however, you do have obligations to the patient. So you need to balance those conscience rights against the patient's rights and potentially patient abandonment. Make sure that you've got a good handle on what your state law requirements are for that so that you can work through those particular issues. All right, I've talked now for about 38 minutes. I'm going to turn the time over to Alex Grande, who's one of our great employment law partners, and she can talk about some more general employment law issues that may apply to all of you.
Thanks, Kim. So we'll start by talking like Kim said, a handful of additional more sort of pure employment issues that are facing all employers, not just folks in the healthcare realm, but that do have some particular importance to folks in the healthcare realm. So non-competes, first of all, as many of you may have followed, last year was a lot of rigmarole and turmoil about this FTC ban that was proposed under the prior administration that would have taken effect in the fall of last year. A couple weeks before it was going to go into effect, there was a injunction that was issued, and of course, we don't think there's going to be any momentum to resurrect this FTC ban in the current administration. So what that means for employers is that we're once again sort of relegated to what states are doing, and states are doing a lot. Ever since the FTC ban was permanently blocked, there have been a number of states that have taken it upon themselves to promulgate additional rules in the non-compete, non-solicit space, more generally referred to as restrictive covenants, and have taken sort of proactive action in there. So there's also a certain trend that I want folks to be aware of, and none of these I think have shown up in the more recent rules that have been promulgated or laws that have gone into effect, but certain states, and Washington comes to mind since it's right next door to Kim and I here in Idaho, we're seeing now the use of affirmative penalties at the state level. So, traditionally, if you have a physician or a nurse enter into a non-compete that ultimately ends up being unenforceable, the penalty to the employer, such that there was one, was traditionally, well, it's just not enforceable. And that physician or nurse or whoever gets to go and work for their new employer. And now we're seeing the use of affirmative penalties in Colorado as well, that says if you have your employee sign a non-compete that ultimately they should have never signed in the first place, you, the employer, can be on the hook for all kinds of things, usually something like a couple $1,000 penalty, but also potentially attorney's fees if it was ever to be litigated. And we're seeing more industry specific restrictions, not just for healthcare, but many that deal with healthcare. So here's a couple of states, just to give you a flavor for what's going on at the state level. So Montana recently, in May and June of this year, promulgated 2 new laws. So the first ban was a ban for most licensed healthcare providers. And then the second expanded their existing non-compete, non-solicit ban to licensed physicians, and also set forth certain exceptions. So there are exceptions under Montana's law for kind of traditional exceptions you'll often see for purchase of a practice, right? And then in Colorado, they are prohibiting non-competes and non-solicits. This is about to go into effect. We have a couple more days here, about 2 weeks, for all healthcare providers, physicians, physician assistants, advanced nurse practice nurses, midwives, dentists. There are some, I think, nuanced exceptions there. And this is something where if you're finding yourself as a cross-jurisdictional employer or with multi-state operations, this is something where you need to dive in with counsel or to figure out what you need to do, if any, as this law is coming down the pipeline. And then in Indiana, this was effective about a month ago. They have removed several barriers to mobility for physicians, so including non-competes, non-solicits exceeding a year, or non-service agreements with physicians. Wyoming, which was frankly a little surprising, I think, to many, recently came out with a pretty broad prohibition on non-competes, but one of those focuses on physicians. And this one is interesting because there also says something about between physicians. So the question that practitioners are trying to sort out there is, what does that mean for mergers and acquisitions, for certain practice areas where traditionally the thought was, look, this isn't really who we're trying to target with non-competes. We're trying to target traditional employees and not these smaller practices where non-competes frankly maybe make some sense. So we'll have to see how that plays out. In Oregon, there's also been some additional restrictions on non-competes, and more than just non-competes, but NDA and any kind of agreements that may affect medical licensees. And there's a broad definition there that also includes naturopathic medicine. And since we're here in Idaho, I'll just say that there are many states like Idaho that still have what I would call the traditional analysis of whether non-compete is enforceable. So looking at its overall reasonableness, one factor of which is whether or not it is a violation of public policy. And often that's where you see the physician or healthcare part of this play in, which is, look, we don't want to necessarily where we need more healthcare practitioners or trying to attract those folks to the state or keep them in the state. When we ban someone from just practicing medicine completely, there's some case law in Idaho that suggests that's per se unenforceable, that's overbroad. But in Idaho and many other states, they use what's called the blue pencil rule to say a court will reform this agreement to be reasonable in some fashion. And so that traditional analysis remains in many states, but what we're not seeing as far as a trend is any states that are making it more common to have enforceable non-competes in the healthcare space. We're seeing just additional restrictions on their use. So in addition to non-compete issues, another issue that I'm seeing or getting a lot of questions about recently has been wage and hour. So common risks in wage and hour are, of course, overtime, things like breaks and misclassification. less so the misclassification Kim talked about at the top of our independent contractors versus employees, but more just traditional misclassification of, is this person exempt? Do they meet the exemption requirements under the FLSA or not, or any state laws that may apply? And one interesting rule I want to draw your attention to, because frankly, what we're not going to see, I don't think too much in this administration, is promulgating a lot of employment rules. I think we're going to see what we just previewed in the non-compete space, which is more and more employment laws just falling to the states, right? And it's getting even more hyper-local in a lot of states like California, Washington, Oregon, where they have specific wage and hour laws or sick leave and other break laws that are hyper jurisdictional, where they're city by city, right? So a lot of states, Idaho is one of them, just has universal state laws. We don't have any sort of sub laws that employers need to be worried about. But more and more, you're just seeing this space as the federal government either is going back and forth and changing rules and revoking regulations or guidance as administrations change. You're seeing the states really fill that void, and it's making compliance more complicated for our multi-state employers and folks that are trying to practice, over state lines. So that all said, one federal rule that I want you to be aware of that was recently promulgated about 2 weeks ago, there's a proposed rule that would make it so that health and personal care aides are exempt from minimum wage protections under the FLSA. And there's a public comment period on this rule that's open until September 2nd. What that means is this rule could change, and we're not going to know what that final rule is going to look like for a while. But the DOL, at least in what it's issued so far, thinks this could affect more than 3.7 million workers. If there's a rollback of these minimum wage rights, the Department of Labor's position has been that, frankly, probably wouldn't impact most aides, because the median hourly wage under the research and analysis that they did seems to say that it hovers around $16 an hour for these type of workers. But the issue, of course, would be more overtime, right? Are you going to have these members or these employees who are now working, more than 40 hours a week, or maybe they're working for multiple agencies? That's sort of the counter argument about, does this, get to a level where we're going to have folks that are just working a lot of time, otherwise would have been, entitled to overtime, not entitled to it anymore. And of course, the counter argument to that, and the reason that at least this rule says it's going to be promulgated, and sort of the rationale behind it, is that there is an aging population that requires more in-home health, and that's certainly how this administration is approaching this rule. So we don't know what that rule is going to look like yet, but just wanted to get it on your radar, and we'll see how that plays out. One very specific break issue that we're seeing more and more are automatic lunch or other breaks. So the plaintiffs bar, a very specific subset of the sort of wage and hour kind of class action practitioners, are well aware that where healthcare employers, often we see this for nurses specifically, but other healthcare providers as well in the nursing field, they'll often have a timekeeping system where there will be some sort of automatic deduction for lunch, often 30 minutes, something like that. But of course, that person worked through that lunch, or at least they later say that they did. And we're seeing a lot of wage and hour claims for these automatic lunch deductions. It's something that, again, is sort of maybe a trend that the plaintiffs bar is well aware of. And there's been multiple cases, including at least one I know of in Idaho, that's been filed. So another issue, moving on, is one that I've seen time and time again, getting a lot of calls on this recently, is the interaction between the FMLA and the ADA. So first of all, just general FMLA compliance issues, general reminder that, when there's going to be a trigger for the FMLA, an employee has a need for leave, that needs to be recognized proactively and gotten to the right place within the organization, right? So the compliance can be met. There's lots of requirements under the FMLA to get that employee certain paperwork within a certain number of days and to be on top of all of those requirements. Now, the other issue that we're seeing is when folks are all of a sudden, your employee's out of their 12 weeks of continuous FMLA and they can't come back, or at least they're not cleared to come back. And we're seeing folks who think that's a termination trigger. And of course, that's not the case. What the ADA may require is some sort of extension of that leave as an accommodation, some sort of consideration of, can we give this employee, some additional time? And where I'm seeing employers get in trouble is where they, instead of going through an undue hardship analysis that's required under the ADA, is just some sort of automatic, we don't do that, or policy to say we're just not going to grant that. We just can't do that, instead of going through the factors and documenting that issue. So just be aware of that particular problem. And then, how can we counteract that? Obviously, just training your manager on post FMLA ADA review obligations, or looping in HR or legal counsel early in the process to figure out, we have this employee that's about to return, and just managing that process proactively. Another issue I'm seeing more and more of is FMLA retaliation claims. So there's the employee returns from FMLA, or maybe they have an ADA accommodation, and then we're seeing retaliation claims sort of increasing, saying, I'm being punished unfairly, or some sort of discriminatory motive in the ADA space because I have an ADA accommodation. And retaliation actions are frankly a little more difficult to defend, just because if there's proximity between when the employee was put on an accommodation or came back from FMLA, any kind of negative, an adverse employment action that happens post return is potentially going to be, a trigger for these thoughts of, look, I'm experiencing some sort of retaliation. And the way, the most proactive thing to do there, of course, is just document any issues that the employee is having, any performance issues or otherwise, proactively. And so there's documentation that says, look, no, this has been an issue that preceded the leave. This isn't just something that we started documenting or looking into after you came back. Of course, what we all know is sometimes that just falls through the cracks. And so more and more we're seeing where an employee comes back, and that's when the employer all of a sudden, where perhaps they should have been more proactively managed with their performance previously, all that documentation kind of gets in place, or frankly, a lot of their issues they were having before are exacerbated, or at least brought to light when they were out on leave. And so then it can look like retaliation, where frankly, it's just that maybe some documentation on the back end would have prevented this type of claim. And then one other issue under FMLA and the ADA to be aware of is just making sure that we're documenting that interactive process under the ADA, not just giving them a form, but making sure that there's, proactive documentation by the employer about all of the steps that are being taken to talk to that employee through the interactive process, and then making sure that you're using the right forms. I'm seeing another issue that I didn't note here, but where, an employer has a form for the ADA or the FMLA, and now we have the Pregnancy Workers Fairness Act, the PWFA, and that's an entirely different law. Well, while similar to the ADA, has some key differences. And so just making sure that your forms are updated and that they actually deal with whatever the specific issue is, and that your handbook, your employee handbook, has been updated to note those differences as well. And your managers have been trained to understand, look, there's going to be key differences here, but sometimes you can have an issue that is going to, if an employee is pregnant, we could have FMLA issues, ADA issues, and Pregnancy Workers Fairness Act issues, and need to be thinking about all of the nuances of those laws and how they interact. So in general, just seeing a lot of issues right now where the employers are calling and saying, hey, how do I reconcile or deal with all of these potential laws? And then that's not even to say anything of any state specific laws that may apply. So if you have any questions, loop in HR early, talk to your legal counsel, and that'll be very helpful to avoid a lot of these trending claims. So in general, and this last kind of point is just about termination and legal exposure, some trends I'm seeing there. So again, kind of previewed this one already, but retaliation after accommodation requests or leave. And then also seeing some misuse of attendance policy. So just usually issues with documentation, FMLA not being documented as FMLA, or it may be automatically counting in some sort of program that is being used by a manager where it looks like an employee is kind of accruing attendance points, when of course they should not. Nothing about that FMLA leave should be counting towards any kind of attendance issues. And then that triggering some sort of claim. And then frankly, just seeing a lot of litigation, a spike in litigation related pregnancy dismissals under the Pregnancy Workers Fairness Act. Again, that's an act that was promulgated and went into effect last year. So I think just a lot of the kinks are being worked out about how do and just some training opportunities that are arising as employers are figuring out how to address that act in particular. And so again, just another opportunity to make sure that sort of those nuances are appreciated, that these are different laws, but that they can interact often. And the key is just always, as usual, going to be consistency in documentation. So treating your employees, the same way, documenting everything, and when in doubt, calling your employment lawyer before you act. And then again, some more tips about how to reduce risk of termination and legal exposure. Reviewing any policies that may have some indirect retaliation triggers, ensuring documentation, consulting with legal before you terminate, or frankly, do any kind of retaliation or something that could look retaliatory, demotion, reassignment, anything like that when there's a recent leave or accommodation that an employee has recently taken. And that's all I have, Kim.
All right, thanks very much. We appreciate your participation today. If you have any questions, feel free to go ahead and you can either submit those with the chat and we'll follow up afterwards, or you can email me. And I'm assuming, Alex, that you would also receive emails and entertain emails. But good luck out there. Thanks very much.